Police pulled over a man driving through Nevada. He had $50,000 in cash in his car. He was not charged with a crime. He was not arrested. He was not taken into custody. The officers took the money, handed him a receipt, and drove away. He spent the next 2 years trying to get it back. He eventually did. Most people do not. I am Ben. Today, I am going to explain what civil asset forfeiture is, how it became one of the most powerful legal tools in American law enforcement, what it has done to people who never committed a crime, and what the law actually says you can do about it. The hook. The phrase civil asset forfeiture does not sound like something that should frighten you. It sounds like a bureaucratic term. It sounds like something that happens to drug lords and organized crime bosses, not to people driving home from the bank. That is exactly the problem. Civil asset forfeiture is a legal process that allows law enforcement agencies to seize property they believe is connected to criminal activity. The key word is believe, not prove, not charge, not convict. They believe. Under civil forfeiture law, the government does not need to convict you of a crime. In many states, they do not need to charge you with a crime. They need to meet a standard of evidence that is lower than the standard required to convict you of jaywalking. They take the property. You get a receipt. And if you want your property back, you are the one who has to go to court and prove it. The property is guilty until you prove it innocent. Read that again. The what? Civil asset forfeiture is a legal action taken against property, not against a person. This is the distinction that makes it work. When the government charges a person with a crime, that person has constitutional protections. They have the right to an attorney. They have the presumption of innocence. The government must prove guilt beyond a reasonable doubt. When the government seizes property under civil forfeiture, none of that applies. The case is technically against the thing, not the person. This is where the names come from. If you have ever seen a case titled United States versus $42,000 in cash, that is a real thing. The government is suing the money. The money does not have rights. You do. But the case is not against you. This distinction was not invented to be absurd. It has a legal history. In admiralty law, going back centuries, courts could take action against ships that had been used in piracy or smuggling, even when the crew escaped. The ship itself became the defendant. American courts carried this tradition forward into domestic law. For most of American history, civil forfeiture was a narrow tool. It was used against contraband, against ships, against property that was itself illegal to possess. The idea was that you could not own stolen goods. The property had no innocent claim to exist. Then came the 1970s and 1980s. The history. The federal government was facing a drug crisis and looking for tools to fight it. Criminal prosecutions were slow. Proving cases against organized crime organizations required witnesses who would not talk, evidence that was hard to get, and defendants who had sophisticated legal representation. Civil forfeiture offered a solution. Take the money. Take the boats, take the houses, make it financially impossible to run a drug operation even if you could not prove a criminal case. In 1984, Congress passed the Comprehensive Crime Control Act. It made federal civil forfeiture significantly easier, and, crucially, it allowed federal law enforcement agencies to keep the proceeds from seized assets. The money went back into law enforcement budgets. This was called equitable sharing. This created something that should concern you. Law enforcement agencies now had a direct financial incentive to seize property. If they seized a car worth $20,000, that $20,000 could go back into their operating budget. For police departments and sheriff's offices running on tight budgets, civil forfeiture became a revenue source. The tool designed to cripple drug cartels had become a funding mechanism for law enforcement, and the targets of that funding mechanism were not always drug cartels. The cases. I want to tell you about some specific cases because the statistics are easy to dismiss and the individual stories are not. In 2012, a motel owner named Russ Caswell in Tewksbury, Massachusetts, received notice that the federal government intended to seize his motel. His family had owned the motel since 1955. It was worth about $1 million. The government's theory was that drug transactions had occurred on the property over the years. Russ Caswell had not been charged with a crime. Russ Caswell had not been accused of participating in drug sales. The argument was that because drug deals had happened in rooms at his motel, the motel itself was connected to drug activity and could therefore be seized. Russ Caswell fought. He had resources and a lawyer willing to take his case, and after years of litigation, he won. a federal judge found that the government's case was based on a deeply troubling theory that would allow seizure of any property where crimes occurred without the owner's knowledge. He was one of the lucky ones. In 2014, a man named Charles Clark had his life savings taken at the Cincinnati airport. He was 19 years old. He had $4,300 on him, money he had saved from working and received as gifts. Airport agents seized it. Their reason was that the money smelled like marijuana and that he could not adequately explain where it came from. He was not charged with anything. He eventually got it back after 2 years, but only after a legal advocacy organization took his case for free. In Philadelphia, civil forfeiture became a systemic operation. Over a 10-year period, the city seized more than $64 million in cash, cars, and property. In one documented case, a family had their home taken because their son had sold $30 worth of marijuana on the porch. The parents had nothing to do with the sale. The house was taken anyway. Families in Philadelphia who had their homes seized were often not told they had the right to a hearing. The city's forfeiture program was run through the district attorney's office and funded prosecutorial salaries and operations. The incentive structure was clear. The more they seized, the more money they had. This is not a hypothetical problem. This is what the law allowed and what agencies did with it. The numbers. The Institute for Justice, a legal advocacy organization that has fought civil forfeiture cases across the country, conducted a comprehensive study of federal forfeiture data. In 2000, federal agencies deposited roughly $300 million in the Department of Justice's Assets Forfeiture Fund. By 2014, that number had reached nearly $4.5 billion in a single year. State and local agencies have their own forfeiture programs operating separately. When you add state and local seizures to federal numbers, the annual total runs into the billions. Here is the number that matters most. In studies of civil forfeiture cases, the majority of people who have property seized are never charged with a crime. In one analysis of Philadelphia's program, 81% of people who had property seized were never convicted of any offense. They were not criminals who escaped justice. They were people from whom property was taken and who either could not afford to fight or did not know they could. The cost of fighting is part of the problem. If the government seizes $1,500 from you, and an attorney costs $300 an hour, and litigation takes years, the rational economic decision is to walk away from the money. The government knows this. The system is structured in a way that discourages challenges. The law. Here is what the law says in most states, and here is where you need to pay attention because this is where it directly affects you. When police seize property under civil forfeiture, they typically have to file a notice with the court within a certain number of days. That notice starts a clock. If you do not file a claim to contest the seizure within that window, you often lose the right to do so permanently. The window can be as short as 30 days. This means that when property is seized, the time to act is immediate. Not after you have recovered from the encounter, not after you have figured out what happened, immediately. The burden of proof in civil forfeiture cases varies by state. In some states, the government needs to show probable cause that the property is connected to criminal activity. That is a very low bar. In other states, the standard is preponderance of the evidence, meaning more likely than not. In a small number of states, significant reforms have raised the bar to clear and convincing evidence or required a criminal conviction before property can be permanently forfeited. The Federal Equitable Sharing Program created an additional layer of complexity. Even in states with strong forfeiture reform laws, local agencies could partner with federal agencies to seize property under federal law, which has a lower standard, and then receive a portion of the proceeds through equitable sharing. This allowed state and local agencies to effectively bypass their own state's forfeiture restrictions by involving federal partners. This practice, called adoption, was restricted by the Department of Justice in 2015 following public pressure and congressional concern. The restrictions were relaxed again in 2017. The practice continues. The incentive problem. I want to be precise about something. Most law enforcement officers are not seizing property because they want to take money from innocent people. The problem is structural, not individual. When an agency's budget depends on forfeiture revenue, seizures become a financial priority. When officers know that seized cash goes back to their department, the calculation around what counts as suspicious shifts in a direction that is not constrained by the requirement to prove a crime. When the standard for seizure is probable cause rather than proof beyond reasonable doubt, the check on that power is much weaker than the check on an arrest. The problem is a system that created a financial motive for seizure and then gave agencies broad legal authority to seize with limited oversight. Some states have recognized this. New Mexico, in 2015, passed legislation requiring a criminal conviction before property can be permanently forfeited and directing forfeiture proceeds to a general fund rather than to law enforcement agencies. The result was a dramatic reduction in civil forfeiture activity. When the financial incentive was removed and the legal standard was raised, agencies stopped using the tool as aggressively. That tells you something about why the tool was being used. What changed? Public attention to civil forfeiture grew significantly after investigative reporting in the mid-2010s documented systematic abuses. The Washington Post published a series called Stop and Seize that documented how law enforcement agencies across the country were using civil forfeiture at highway interdiction stops to generate revenue. Congress held hearings. Several states passed reform legislation. The Institute for Justice, which had been litigating forfeiture cases for decades, saw increased public and legislative interest in the issue. The reforms have been uneven. Some states have raised the evidentiary standard required for forfeiture. Some have eliminated the profit motive by directing proceeds away from law enforcement agencies. A few have required criminal convictions before forfeiture can proceed. At the federal level, the standard remains lower than most people assume. Federal agencies can still seize property on probable cause. The equitable sharing program, while subject to restrictions that have varied by administration, continues to operate. What this means for you. If you are ever in a situation where law enforcement is asking questions about your property, cash, or assets, the rules that govern that encounter are different from what most people expect. First, you have the right to refuse consent to a search. A traffic stop does not authorize a search of your vehicle without consent or probable cause. If an officer asks to search your car, you can decline. You should decline calmly and clearly. Refusing consent is not evidence of guilt, and it is not grounds for a longer detention by itself. Second, if property is seized, do not assume the process is final. Ask for a receipt. Get the exact name of the seizing agency and the case or reference number. The clock on your ability to contest the seizure starts when you receive notice, and that window can be short. Third, the attorney you need for a civil forfeiture case is not necessarily a criminal defense attorney. Civil forfeiture is a civil legal process. You need someone who understands both the state forfeiture statute and the federal equitable sharing rules if federal agencies were involved. These are two different bodies of law. Fourth, document everything. If you are carrying large amounts of cash, document its source before you travel. Bank withdrawal records, business records, gift documentation. The burden in many forfeiture cases falls on you to show that the property is not connected to criminal activity. Evidence of a legitimate source is your defense. Fifth, contact the seizing agency in writing immediately. Oral communications about forfeiture cases are not reliable. Everything should be in writing and everything should preserve your right to contest the seizure. The complete picture. Civil asset forfeiture is a legal tool that was designed to attack the financial infrastructure of large-scale criminal enterprises. What it became in practice is a mechanism that takes property from people who have not been convicted of crimes, often from people who do not have the resources to fight, and directs the proceeds of those seizures to the agencies doing the seizing. The incentive structure is not hidden. It is written into the law. The result of that incentive structure is documented in the data. Billions of dollars seized annually. The majority of people whose property is taken never charged with an offense. Agencies with budgets that depend on continued seizure. The reforms that have worked share two features. They raise the legal standard for seizure so that taking property requires something closer to proof. And they remove the financial incentive by directing proceeds away from law enforcement budgets. Where neither of those reforms exists, the pattern continues. The legal standard for taking your property is lower than the legal standard for convicting you of a crime. That gap is where civil forfeiture lives. Understanding it exists is the first step. Knowing your rights in the moment is the second, and knowing how to fight when it happens is the difference between getting your property back and losing it forever. Understanding the difference between what the law permits and what most people assume the law requires is why I make these videos. If this was useful, subscribe. New video every day. I will see you tomorrow.